Today, we're breaking down a fascinating legal structure. The Private Membership Association, or PMA. Can a group operate in a private domain outside the reach of many public regulations? Proponents ground this claim in the U.S. Constitution's First Amendment right to associate. And they don't stop there, citing amendments that protect privacy and due process. We'll show you the benefits, real-world uses, and the serious risks you need to know. Fundamentally, a PMA is a group of people joined by a private agreement. It's an unincorporated association based on the right to choose who you associate with. This idea isn't new. It has roots in the exclusive private clubs of past centuries. These were spaces for members only, operating under their own internal rules. The single most vital concept is the distinction between the public and private domains. The public domain is where government regulations apply to all. The private domain is governed by contracts between members. When you join a PMA, you sign that private contract, agreeing to operate under the PMA's internal rules. The powerful implication is that within this bubble, members can exchange goods and services on their own terms. This concept is the basis for every claimed PMA benefit. So if they can set their own terms, what are the actual advantages people want when they form a PMA? First, potential regulatory flexibility. Since they aren't serving the general public, some business laws may not apply. Second, privacy. In a private association, members have more control over their data. This is a huge draw in an age of data collection. Third, a strong community. PMAs attract like-minded individuals, creating powerful networks of trust and mutual support. This sounds great, but how far does this protection go? For instance, could a doctor practice medicine without a state license? You'll find out the answer shortly. To manage themselves, PMAs have bylaws and are usually run by a board or trustees. These leaders are often elected, ensuring the association serves member interests. We've covered the theory and the claimed benefits. But who is actually using PMAs in the real world, and for what purpose? You'll often see them used by wellness coaches or alternative health practitioners to offer services directly to members. Educators and learning co-ops also use PMAs. This structure permits them to create and follow unique curricula for member families. Even small farms or food clubs use them to sell goods directly to members, operating on trust and private agreement instead of public commerce. Critically, in all these cases, you can't just walk in off the street. Membership is private, reinforcing that it's not a public-facing business. This all makes it sound like a powerful legal shield. But is it impenetrable? Now for the part everyone gets wrong. Let's be absolutely clear. A PMA is not a get-out-of-jail-free card. They are not exempt from all laws, and thinking so is a dangerous mistake. PMAs must honor contracts. They cannot commit fraud or discriminate based on race. If a PMA causes clear harm, authorities can and will intervene. Here is the single biggest risk. PMAs are often unincorporated. If the association gets into debt or is sued, members can be held personally liable. Your assets are at risk. So, back to our question. Can a doctor practice without a license in a PMA? Proponents argue yes, but this is a massive legal gray area. Courts can view this as an attempt to evade public safety laws, leading to shutdown and prosecution. The legal ambiguity can attract intense regulatory scrutiny. Recall the private domain created by private contracts? That's the source of a PMA's freedom. That same structure is also the source of its greatest risk, personal liability. Let's bust another myth. PMAs are not automatically tax-exempt. A PMA does not eliminate your obligation to report income and pay taxes. And don't confuse a PMA with a 508c, non-A1A. That's a specific designation for churches and their associations, not a general shield for all PMAs. So what we have is a structure that offers real potential for autonomy and privacy, but it comes with significant considerations. The story of the PMA is a trade-off. You are trading the protections of public regulation and limited liability for greater privacy and autonomy. It's a potential tool for those deeply committed to a mission and willing to handle complex legal territory. It is not a simple shortcut. Our final take: a PMA is not a magic bullet to escape the law. It is a complex assertion of constitutional rights that requires expert legal counsel. Share this video with anyone looking at alternative structures. What are your thoughts on this trade-off between freedom and risk? Tell us below.